So, hello and welcome you to this session about an introduction to patents. Uh, I'm going to deepen a little bit our knowledge about the patent. So, in this session, we will talk about some other aspects. We will, first of all, of course, talk about um, what is a patent in general and so on and so forth. But we are going maybe a bit further to that. We are talking about also some very practical aspects of the patents, as for example, how does a patent look like, and maybe even actually a little bit about drafting parts of the patent. So to the content, what we are going to do at the beginning, we are going to give you a brief introduction to the patents, deepening what we learned in the first part. And then after that, of course, I will talk a little bit more about what are the claims. And once I explained a little bit about the claims, we will have an example of claim drafting, how normally a claim is drafted, so that you become more familiar with these very particular language, which is the patent language. It's bit maybe strange at the beginning, but that is the way normally a patent is written, and it is even actually necessary to write the patents. We will learn that it is necessary because it is something which deals with the fact that a patent in general is also a legal act. So we need actually that a legal strengthen of the language in that. Then I will finish with the let's say simple explanation about the structure of a patent, and we will see how does a pattern look like. In this part will help us a little more, and we will understand why we need that particular structure when we are talking about patent searches. So first question to be asked is actually, what are the patents? Most of us have heard about patents. Most of us have even actually at least an idea about what are the patents, and maybe we have some imagination about the patents. Uh, from time to time, we have also uh, some funny stories about patents, and these stories exist also. So let's start the whole thing with a little bit more fun about these sort of indispensable inventions, for example. So what I ask you is now that I will show you figures which are coming from different patents, and the good thing about most of the patents is that just by looking through the figures, you might understand what the patent is about. And in some of the cases, you even can imagine where the patent comes from. So let's take a shot on that, and you will tell me what is the patent is about, what is the patent about, and then the second question is actually where does the patent come from? So give you 10 seconds to think about it. So maybe you found it out. It is about a sausage. However, what sort of a sausage? Because sausage as such is not new, so it can hardly be possible to patent that. That is a special sort of sausage. What is the specific part of the sausage that makes it new and inventive? And that is in fact the number three. In the figure you can see under the number three, these sausage has a filling. So and that is in fact what the invention is about. This is a sausage with a filling of mustard. You might even actually think of the country where the patent does come from. It comes from Germany in that case. That is one of the patents. Then you have a second one. you might actually now think about what is the patent about and where does it come from. Okay, so uh, have you guess? Yeah. For those of you who thought that might be actually, let's say, a beer hat, no, that's not a beer hat. That is a wine hat. So, in fact, the whole patent is about an invention of a beer hat. Somebody who has actually had like, about a wine hat. Somebody who has actually a hat in the form of a wine barrel. So what is it good for? I don't know, but that is also a patent, of course. Then the question is, in fact, okay, so from which country? So most of the time, you would think that it might come from a very famous wine country, like for example France, but it's not France. It's not Italy neither, for example, which is also another very known country for the wine. But what we forget normally is actually also United States is a wine country, and the patent is coming from United States. The third one, so if you look thoroughly to the person which is showed here by number 8, you will something around his or her chest. So in fact, that is the reason of this patent application. It is about a device to capture who? To capture a suicide bomber. That is also a patent application, and you can find also the way how it is done. So that is how they found out to capture this guy who might be a threat to other people. So from which country? Yes, again, that is a patent from United States. Then, even actually very famous people have their own patents, as for example, that is the case of a very, very great pop idol, which was Michael Jackson. Michael Jackson has his own patent, of course. That is the patent about this shoe that allows him to have a very unnatural, let's say, angle to the scene. So as you see, actually, the whole thing is done due to the fact that these shoes is prepared in a certain way so that the heel give him the possibility to go to decline to a certain degree, which is quite unusual, unnatural, and give him the possibility to come back to the situation before. That is actually also a patent, of course. That's a patent which belongs to Michael Jackson, or it belonged to Michael Jackson at that time. So you see, even actually very famous person like Michael Jackson might have a patent. Of course, when we are talking about patents and we see these beautiful patent, let's say, these beautiful patent yeah, examples as we see here. Um, some of them make you laugh, some of them actually are funny to see. You might have the impression that the patterns are something very funny and very, very about things like these types of invention. That is not true all the time. In fact, patents are quite serious things, in fact, and they are having a very special duty, and that is an economic benefit. The idea of having a patent is not to be funny, in fact, even if sometimes that might be funny, but having a funny patent might not have the effect that you wanted from the patent, namely to have the economic benefit of that patent. So here again, what we are talking about, there are these facts. Some of them are quite common, among all, let's say, IP rights, and they are also valid for the patent. For example, a patent is an exclusive right. Being an exclusive right means that once you have these patent rights, you can exclude other people using the patented case in a commercial way. At the same time, an exclusive right is not on the same manner, let's say, an executive right. It is not a guarantee that you can use the right yourselves. So be careful about these distinction between executive right and exclusive right. A patent gives you the right to exclude other people's, but it does not give you automatically the right to use. Just for an example, please think about having a patent about a medication. The idea is actually, can you sell the medication the next day as the patent is granted? And the answer is no. In most of the countries, you have a drug administration. That is for example, in the case of United States, it's called FDA, Federal Food and Drug Administration. And for the case of Switzerland, it's called Swissmedic. In many countries, there exists some sort of let's say administration which shall give you the approval before you can sell your drug. So to sell a drug, you need actually the approbation of that administration. For that, you have to bring a lot of documents, a lot of proof that your drug is really safe and it helps people not is it's not a danger to the health of the people. So that means, in fact, again, having a patent is not a guarantee for the utilization, especially for that case. Then a patent is an IP right, and like all IP right, it undergoes a sort of principle which is called territoriality principle. Uh, Again, having a patent in one country does not mean that you have the exclusivity in other countries. If you have a patent, we said it before, if you have a patent, for example, in Indonesia, that does not mean that nobody can make it in Malaysia or sell it to China. So if you don't want that people are making that in Malaysia and sell it to China, you have to have a patent in Malaysia and in China, at least. It is only valid in the country or in the countries where the right is granted. Then, patent is never hidden. There are no hidden patents if you want. Uh, all the patents are in fact recorded in a national or sometimes in regional registers. So if you want to find out if the patent exists in that on these countries, what you have to do is actually to go through the registries of the countries and look for that patent. So normally actually patent shall be registered in registry, otherwise people would not know that the patent exists. And that is also a duty and an aspect of the patent, and why the patents are not hidden, because a patent shall bring what we call the juridic security, which means, in fact, it shall bring to the people a legal security. When, I mean, if a patent exists and no one can know that the patent exists, how can you avoid infringing that patent if the patent used to be hidden? So there's no way of doing it. You cannot actually ask people not to infringe something they cannot know that it exists. That is why a patent is always published and it is always recorded in a transparent way in a registry. Then a patent is meant to die one day. So most of the time, in most of the countries, there is a maximum life of a patent, and this maximum of life is around 20 years. Most of the countries have actually 20 years. So in order to keep the patent alive for 20 years, in most of the countries, again, it is not automatic. It is not so that actually you apply for a patent and you have the patent for 20 years. Most of the time, you have to pay annual fees, which means actually you might ask by paying an annual fee to make a prolongation just for 1 year, then another year, up until the date of 20 years. And that at that moment, that patent will die. So whatever you want to do from that moment on, wherever you are, that is too late. The patent will die. Then again, a patent is not thought to be used as a tool against private use, against education, against research, and so on. So there are some privileges which is accorded in different patent provisions. Most of the patent provisions you find, for example, the so-called research privilege, which says that the research on the patented subject is allowed. That does not mean that actually you can use that patented subject in order to make something else. But if you want to verify if that patent functions and you can do a research on what is said, then you are allowed to do it. It is also said that it is, in fact, free for private use. We said that a patent is an exclusive right to exclude third parties using it commercially. A commercial use is something else than a private use. In other words, if you find a patent, normally you can, in fact, build what is said in that patent. You can use that patent for your own use. You are not allowed to use it commercially, but for your private use, you can use it. Also for educational, let's say, necessities, you can use the patent. And patent is a right like any other right, and once you have it, you can do whatsoever what you normally do if you have a right. Let's say, for example, a house is a right also. So if you have a house, it means actually you have the right of possession of that house. What can you do with the house? You can transfer it, you can sell it, you can give it in heritage, and you can, for example, rent it. All that is also possible in the case of patent. You can sell the patent, so it is transferable. You can give it in heritage, and you can give licenses. Licenses is somehow comparable to renting a house, but it is even bit better because normally if you rent a house, you cannot re-rent the same house to another person. It's just rent once. But if you have a license on a patent, because patent is an intellectual property and not a material property, you have the possibility to make other licenses to give it to other persons as much as you want. So licensing is also a way to earn money from your intellectual property right. In most of the countries, the question of who owns the patent, who owns the we call it actually the right on the patent, is decided by the first to apply approach, which means in fact the first one who applied for the patent will be given all the right, and anybody else who comes later in that country won't have the right. So if two persons apply for the same patent, the one who actually applied first will win the race. Uh, that is actually very important to know because that is a question of just application date, not the invention date. So again, it is not about who first invented the let's say the invention, but who first applied for that. It might seem that, for example, the invention data, so first to invent, would be actually much more fair play. So it is something which is the one who invented first, who he shall have the right to actually gather the fruits of that invention. But the point is actually the invention date is never an objective date. It is always a subjective date. Who can tell us at which date who invented what? Uh, on the other part, the application date is an objective date. You will be given this date normally by your office. So first to apply is actually the one who wins the race. Last but not least, actually, and that is very important because that is the basis of what we are going to see when we are talking about actually patent searches. All the patents are published. And thanks to internet nowadays, it is a worldwide publication. That means, in fact, a patent is not only not hidden, but also there is an international publication for everybody else. That is two very, very points which is actually included in this sentence. First of all, we can search for patents because they are publicly available. Okay, we will use that idea. On the second thought, I have to say it is also very important because that is what happened to you. Remember, we said a patent right is a territorial right. You have it just in the country where you applied for. On the other side, the publication is worldwide. So you give away your knowledge to the whole world for having, let's say, an exclusivity in certain countries. So that is the point you have to decide about yes or no for patents because on the one side you have territorial right, on the other side giving away internationally the knowledge. So you have a balance. You have to find out if it is actually worthy or not. Most of the cases, it is the only thing you have. If you don't have even a patent, you don't have anything, and you give the knowledge away for everybody without having anything in return. So that cases, yes, it is worthy doing that. In other cases, you might actually keep the knowledge for yourself. It is maybe possible to keep it secret. That would be actually a way to have the idea for yourself without these publications. So the publication is a very important part of the patenting, and we are talking just about what is published because of course that is another question we have to ask ourselves. I told you the patent is published, but I didn't tell you what is published. We will see just in the next slide what is the information which is published on these publications. So the question is what is disclosed in a patent is also very important because we said patents are disclosed and published worldwide. And now is the question actually, okay, so it is published worldwide, but what is published worldwide? Maybe it is enough to say that I have an invention and that is published worldwide. So in that case, actually, it's quite good because I did not say what the invention is. Or maybe I can actually just disclose that there is a black box out there that and these black books makes that invention or make that invention possible. Is it enough to be published? This question is actually answered and addressed in different laws and provisions, and even actually in a very important, uh, maybe the most important agreement on IP rights at the international level, which is actually TRIPS. And it is said, for example, that what shall be published. A disclosure shall be there, and this disclosure is in fact so. The invention is so disclosed that it is sufficiently clear and complete for a skilled man in art, skilled person in the art, in order to carry out the invention. So it is not enough just to say, I have an invention, or there is in fact a black box who is doing that. It shall be clearly disclosed so that a person of the skilled person in the art can carry out the invention. So he has to be able to read it, to understand it, and to do it, and he shall get exactly the same result as you are describing in the patent, which is very important condition to get the patent. That is actually the point that everybody shall think about it. Uh, is it enough what I have in order to get the patent, yes or not? On the other side, I told you, you have to be careful about actually what you are doing, because you are asking for a patent in some countries, but you are giving away that disclosure to the whole world. So the question is actually what is really worthy or not. So it is not the only, let's say, condition to get a patent. In fact, there are several patentability criteria. Now let's take a close look at that. What is really patentable? What are the patentability criteria? There are several, as I told you, patentability criteria. So it works like a funnel. You come in with the idea, and it will be examined if all of those criteria are fulfilled. If yes, on the other side, you get out your patent. So very first and very important, let's say, criterion to be patentable is, of course, technicity. Is it technical? As we said, a patent is a technical solution to a technical question. So if it is not technical, it's not patentable. Then, very important also, it shall not be against morals and conventions. A problem there might be actually what are moral and conventions. You know better than me that moral and convention can change from day to day, from country to country. So what does it mean being not being against moral and convention? We are coming back to that. We will see that people tried actually to clearly put some aspects there so that it's clear what we mean that. Then another very important part of it is that to have an industrial application. What is an industrial application? Again, maybe just by hearing industrial application, you might think of something which is done by the industry, which is not wrong. In fact, industrial application, that is the counterpart, if you want, of private application, what you use in private. But it is not the only reason when we are talking about industrial application. We say, for example, something has an industrial application if you can sell the thing. The point is like, yeah, everything can be sold. Yes, everything can be sold if it is there and it is repeatedly there. So industrial application includes also the feasibility and the repeatability. We are going again to talk about that subject also a bit more in depth. Then the thing that most of us have heard of us, that is novelty, of course. The invention shall be new. Again, how new is new? Is it enough that is new in my country, for example? And we will see, no, it is not enough. In fact, novelty, as we see it in the world of patents, it is absolute and worldwide. So absolute and worldwide novelty. And then last but not least, the inventive step, which means that even being new is not enough. You shall imply at least an inventive step. So we'll see that inventive step means, in fact, just by adding some features to what existed in the state of the art. Imagine, for example, everybody has only black cars. No, what you do is, in fact, you just color that black in green. And now there are some green cars. Again, it is technical, it's not against morals, it has some industrial application because you can do it. And it is even new because you had only up until now black cars. Now you have actually the green car. So is it enough to have a patent, yes or not? And we will see that is the inventive step who comes in and says, okay, it is maybe new, but it is not enough to have a patent because besides being new, you need to have an inventive step. So let's go uh, uh, and talk about each of them separately. So, technicity. In fact, it is quite difficult to make a positive definition of word technical. Everybody has an idea about what is technical, but it is not so easy. And I don't know. I personally don't know. I hope you maybe know that, but I don't know any positive definition of the word technical. We use it, in fact, also in a reverse manner. We are talking about things which are not patentable because of the lack of technicity. For example, discoveries, scientific theories, and mathematical methods. These are not patentable because, for example, a discovery as such has no technical effect. I mean, discovery is that what you found in the nature, so as itself does not have any technical effect. If, however, that property is put to practical use, then these constitutes an invention, and that might be patentable. For example, the discovery that a particular known material is able to withstand mechanical shock would not be patentable. But a railway sleeper made from that material could well be patentable. So you see, in fact, discovery is just finding out what happens in the world, and if you make an invention out of it, then it becomes patentable. Scientific theories are a more generalized form of discoveries. For example, the physical theory of semiconductivity, and that cannot be patentable. Of course, if you do some semiconductors using that theory, and these new semiconductor devices are all patentable. Then mathematical methods are purely abstract or intellectual methods, and these are not patentable. So if you find a new shortcut method for division, of course, it is just a pure mental act and it is not patentable. But every calculating machine might be patentable. And that is actually two different things. One is actually a mental act. The other one is a technical, let's say, device that does these type of, let's say, transactions. Then all aesthetic creation, for example, painting or sculpture, uh, these have aspects which are other than technical effects, and these are not patentable. For aesthetic creations, you have other possibilities, of course, of protection. For example, there are industrial design, we have heard in the first part, or also there exists the copyright on that. Then about scheme, rules, methods for performing mental acts, playing games, or doing business, all that are, of course, not patentable because these are in fact more or less mental acts and pure non-technical effects. However, if the claimed subject is rather about or needs the use of specific apparatus to carry out at least some of the steps of the scheme and so on, then you have, of course, a technical interaction through that apparatus, and then it might be technical. So at least the technicity might be there. So just the method and so on, not enough. The same goes for presentation of information, uh, which is not patentable. But if the presentation of information has new technical features, there could be also some patentable subject matters. And so that is again just pure presentation of information, not because to lack of technicity. If you have some technical effect in that, then you might have it. So again, it is difficult to say what are these technical effects and where they come from. So normally we can imagine that in fact, if it is about a device, if it is about an object, a physically existing object, we don't have any problem with technicity. It is technical. If there is object there, so it is technical. An object, a device is per se technical. Most of the time, there are some technicity problems, technical lack of technical effect problems if it is about a methods. So we have technical methods and non-technical methods. Non-technical methods are the ones that they don't use any laws of nature in order to make a change, for example. So if you have a method during which you use the laws of nature in order to make a change, then the technicity might be there. So that is more or less about technicity. Then we have what is against moral and convention and what is it good from. In fact, what we can say is that these article comes in, or these patentability criteria comes in two different provisions for the simple reason that people do want to protect the inviolability of human dignity. And of course, not only that, but also not to accept inventions which are against public policy or order. For example, leather bomb. I mean, it might be very technical, very new and inventive. Nobody wants a patent for a letter bomb. I mean, no country wants it, or no country can accept a patent about devices for cruelty to animals and so on because they are not moral. However, this question of what is moral, what is not moral, it is, I said, it is, or what is the human dignity, for example. These are questions which are of other type as what we had about technicity and so on. So people had to make clear what it is. So they put things into provisions. You find, depending on the provision you are looking at, things like that. For example, therapy methods, diagnostic methods on human or animal body is not patentable. Not because it is not technical, not because it is not new, but because people did not want that a doctor cannot work. These methods are things that the doctors are using, these methods, I mean. Then parts of human body or human body as all in the natural environment cannot be patentable. That is actually also excluded from patentability. Human cloning is excluded from patentability in many provisions, at least in the European provisions. And also unmodified human embryonic stem cells, of course, exactly in order to make clear the human dignity. So these are set in different let's say, provisions more or less clearly. So in most of the European provisions, you find things like that. So methods for treatment of human or animals on human or animal body by surgery or therapy or diagnostic methods. For example, a method for treating cancer, a method for diagnosing Alzheimer's disease. All that is not patentable. As I told you, it is not because people thought it is not technical. They excluded it from patentability because it is not a situation for a medical doctor if there is such a patent there. That is what a medical doctor does. You cannot go to a doctor. The doctor says, "Oh, I cannot touch you. I have to look if I don't infringe any existing patents, then he can maybe touch you." So it is not possible to do that. So they said, we don't patent it from the beginning. There are other provisions, for example, in the United States, where these exclusion does not exist, but the provision has some other articles like saying that these method claims cannot be used against doctors. So if you cannot use it against somebody, why do you have it in your patent? But okay, so that is another solution of the same problem. Then plant varieties and animal breeds and all essentially biological processes for breeding them are not patentable. That is, again, if it is essentially biological, it means that the nature does it, not you. So if you are just involved as somebody who is looking what happens, it is not enough to get a patent. You cannot maybe actually, and the other problem is actually these essentially biological processes are normally not repeatable because that is the laws of nature, so selection and so on. Maybe it comes to something which is good, maybe not, and that is what we cannot accept because we need the repeatability, particularly in that case. Then also, when it comes to morality or public order, in many provisions, it is said what they mean. For example, you see that it is said that the cloning of human being is not morally acceptable, so it is not patentable. The use of human embryos for industrial or commercial purposes, then process for modifying genetic germ line identity of human beings, process for modifying genetic identity of animals that cause them suffering without any substantial medical benefit to man or to animal, or unchanged embryonic stem cells, or the human body at all stages of its formation in the natural environment. So all that shows that actually, okay, so there are some outlines there which says what is moral and what is not. Uh, of course, what shall be taken into account is that, for example, if you go through the list, you don't see anywhere that I have said, or the right or the law has said, that cloning of animals is prohibited, or not prohibited, but cloning of animals is not patentable. I mean, if you say, I said actually cloning of human being is not patentable, but you cannot find something about cloning of animals. So if the question is it is the cloning of animals something, I don't know, moral, and it has no moral problem? I don't know. It is not what we have to decide. That is what was decided by the lawmaker. The lawmaker decided cloning of human beings not patentable, but cloning of animal is patentable. So that is the state of the thing. If it is moral or not, I don't know. That is a decision which was made normally by the lawmaker. Then there are also, if you're in the exclusion of patentability, we have to make sure that not everything shall be excluded. In fact, if you look at the TRIPS, it is said a member may exclude from patentability plants and animals, as we have said, or essentially biological processes for production of plants and animals. Okay, it is in Europe the case. Essentially, biological processes are prohibited for patentability. However, the TRIPS says clearly that members shall not exclude from patentability the microorganism or non-biological and microbiological processes. So why are microbiological processes accepted as patentable? For the simple reason that these type of processes are done by human being. It is not something which is done by the nature. So human being has to interfere to, in fact, carry out that type of processes. So members are allowed to exclude essentially biological processes, but they shall not, for example, exclude from the patentability everything which is done by the laws of technical effects like microbiological processes. And what comes out from them are the microorganisms which come out from those type of microbiological processes. In summary, an invention, especially in biotechnical field, a discovery is not patentable. That is what you find in the nature as it is. You describe something existing that helps maybe the extension of human knowledge, and so it is not patentable. Uh, you find, for example, you find out that certain types of fungi can kill certain type of bacteria. So that sort of fungi can kill a sort of bacteria is something which happens in the nature, and you just looked. I admit it. You looked quite carefully, more carefully as anybody else, because you found it as the first one. It is a discovery at your name, but it is a discovery because you did not do nothing. That is what happened in the nature. You just observed it. Now, you use the same observation and you make an invention out of it. So it means you found out an instruction how to solve a technical problem. And that is, in fact, the extension of human abilities, no more knowledge. So you found out that if I put these type of fungi in a certain form, then I can cure some bacterial disease. You make antibiotica out of it, and then it is patentable. So discovery, not patentable. Invention, patentable, especially if it can be assured that is new, inventive, and the further, let's say, criteria, which I'm going to talk about them in short. One of the other criteria which is necessary for the patentability of an invention is, in fact, the industrial application. Just by thinking about the words which somehow make these combination, industrial and application, one might think about everything which has to do directly something with industry, something like production, like manufacturing, like part of agriculture or fishery, and things like that. On the other side, if you think about industry, you might think about the contrary of it, which is actually private use, everything which has to do with household, with sport, with hygiene, and so on and so forth. So, on the one side, of course, it has to do something with industry. I will say that industrial application goes beyond just the simple idea of industry and private use. Of course, industry and private use are part of it, but the criterion of industrial application is much more than being part of the industry and not being part of the private use. So one of the first thing what we think of when we are talking about industrial application is that in fact the invention shall be reproducible. So as I told you, the reproducibility is also part of industrial application for us. What it means is that uh, if something is just the result of an accident, or because the nature somehow actually decided for that, then it is not patentable due to the lack of industrial application. Imagine you have a black rabbit and then you have a white rabbit and you cross them. I mean, there is sure some possibility that you might have in the first crossing one of the children which has the form of a zebra. We have a zebra form, let's say, there is some probability to have that that you have actually the zebra form rabbit child. But the point is that is nothing you can decide because you did it just by letting do it. So the reproducibility is also very important part, and here that is not granted. So you can maybe grant for that reproducibility. In that case, if you don't do it in a natural way, if you do it by some, let's say, technical methods, if you do these crossing by using genetics, so that the result is always a zebra, let's say rabbit, in that case, you have at least the criteria of reproducibility, and that can be accepted for the patentability. So reproducibility is quite a very important part of the technical solutions in order to be accepted. Then another part of it is, in fact, you shall achieve the goal of invention. So it is not just enough to mention in the disclosure that you will achieve the goal, but in fact, you are somehow obliged to describe it in a manner that a man of skill can achieve the let's say stated goal by using the stated means. So it is a ground of refusal, that is actually reason to refuse an invention if it is, for example, against the laws of nature. If it is about a sort of perpetuum mobile, that is some machine that can, they cannot of course, but people can imagine these machines where you might actually earn more energy than you put into the machine. So it is actually against the laws of nature, it is against the laws of physics. You cannot have a machine that produces on its own energy. So machines, in fact, they consume energy, they may deliver energy, but the delivered energy is at highest as high as the consumed energy. So we cannot have more than that. Those type of so-called inventions are not accepted because lack of industrial application. You cannot, in fact, achieve that goal. Another thing is, in fact, in order to assure that the disclosure of the patent is done correctly, uh, these shall be granted by a criterion, and this criterion is industrial application. So, in fact, if you cannot achieve the goal with the stated means, it means either it cannot be achieved, so it is not patentable, or you did not disclose it thoroughly and enough so that a man of skill can do it by reading that disclosure. And that is another reason of losing the patent. So again, very important, you need to disclose the patent. And another point that might make you lose actually the patent is actually you have not to exaggerate. If you, for example, say, I can achieve, let's say, some sort of yield about 80%, and by following what you say, people achieve only 70% of the yield, that means that, in fact, you exaggerate it. So either maybe you can achieve 80%, but you did not say it, or it is not disclosed in a manner that the man of skill can do it. So that is again the reason of having this criterion. It's not only I say it is, of course, that it's not only being part of industry, but also being reproducible and being disclosed in a manner that a man of skill can follow it and can achieve the stated goal by what is in fact disclosed as the necessary means. Another very famous and, of course, very well known criterion of patentability is about novelty. Now, you have also to understand what the novelty is. The novelty is saying that the invention shall be new, but how new is the new? And the novelty as we see it in the world of patent is absolute and worldwide. So in fact, one says that, let's say, an invention is new if at a day before application, so you have actually done your application, for example, today, yesterday, so the day before application, it was not part of state of the art. So the question is, what is state of the art? And in fact, state of the art is everything which was rendered by use orally or by a, let's say, a written publication, somehow rendered, somehow accessible to a public one day before the application. So that is how the state of the art is defined. So you need one day before application, and however the manner is. It is very important that you understand this point, because it includes also your own publications. If you publish in any manner, if you publish it in any manner, one day before you asked for the application, in fact, you killed the novelty of your invention. So it is very important for people who are thinking of a patent application to keep it secret up until the day of application. From that point on, you can talk about it without any problem. But until the day of application, you shall keep it confidential. If you actually talk to a friend of you and you ask your friend, for example, to keep it confidential, that might be enough. You have some sort of agreement with your friend. That is actually an oral agreement. Well, why not? You have an oral agreement which states that it is actually kept confidential. Now, the oral agreement goes between you and your friend. Now, think you might go to a bar in order to tell to your friend what the invention is about. And the bar is a bit too loud, so that you have to talk a little bit louder so that your friend can understand what you say. It might be loud enough that somebody behind you could have heard it. I did not even say that he heard it. I say he could have heard it. So, so as said, it is maybe enough that, in fact, to speak too loud so that somebody could have heard you would be enough to kill the novelty of your invention. So it is very, very important that these confidentiality is somehow kept. So don't forget about it. But there is a good thing about actually novelty, because novelty includes, in fact, that all the necessary features of the invention shall be disclosed in the state of the art in one piece. So it is not enough, at least not for the novelty, to have half of the disclosure somewhere and half another half in another place. So I don't say that if it is like so, you will have a patentable invention. I would just say that is new. In other words, in order to have something new due to the state of the art, you only need to add one more technical aspect. Then it becomes new. So you have the state of the art, you put just one more technical aspect to that, and it becomes new. Now, if it is patentable, it depends on other criteria, of course, but at least it becomes new. So in order to understand how the novelty is really judged, let's try together to decide about the novelty of an object due to the state of the art. So let's think of the following situation. Uh, Somebody asked for a patent for this invention, the invention you see here, and this invention was described by the following actually features. Uh, it is a vessel for watering plants, which has a water container, a grip, an opening with top cover, and a spot. Now, the question is, in fact, okay, now I can actually go and search in the state of the art. It is all about the search, what we are talking now, because later on we'll use this knowledge in order to go and make a search of our own. So we have to decide, if I find something in the state of the art, if what I found is relevant due to the novelty of these objects, yes or no. So again, it is about a vessel for watering plants, having a water container, a grip, opening with top cover, and a spot. Now I look through the state of the art and I find the object A. Object A is what I found. So I don't know, maybe some of you are familiar with that object. It is in fact, uh, it's normally said it's an oil can. We have actually an oil can. And the question is if this oil can relevant to the state of the art or relevant to the novelty of this application. I let you think about it about 10 seconds. So now we go back. So some of you might actually have said yes, some of you have said no, but let's have a real answer to that question. Is it yes or no? Well, my answer as a patent examiner to that question is yes. This object A is relevant to the disclosure of the invention I have here. So it is, first of all, the very first question you might find is it really a vessel for watering plants? It is an oil can. Yes, it is an oil can, but who said that you shall use it as oil can? A vessel for watering plants says just that you can use that for watering plants, and you can in fact use it to watering the plants. So yes, it is a vessel for watering plants because it is, you can use it for that purpose. Then, has it a water container? Yes, it has. It is an oil container, but it can also be a water container. There is a grip on that. There is an opening with top cover, which is here where the oil comes in, and you have a spot. So you have all the necessary let's say, criteria, all the necessary features which was disclosed in that invention. So A is relevant to the novelty of the object. What about B? Is it relevant or not? Let you still, let's say, 10 seconds. Again, let us look thoroughly if every feature is there. We know that is in fact exactly what he wants. It is about a vessel for watering plants. So does it have a water container? Yes, it has. It has a grip. Yes. It has an opening with top cover. Sorry, there is no top cover. There is just an opening there without any top cover. And even if there is a spot, it is not relevant to the novelty of the invention. So you see, B being exactly the same thing because of lack of these top cover might not be relevant to the novelty. I don't say that if this invention is patentable over B. I just asked if it is new over B. Yes, this is new over B, but it is not new over A. Then the next question is actually, for example, if C is relevant to the novelty of this object. I let you 5 seconds this time. I'm sure that most of you have said yes, it is not relevant, that there is actually no relevance of a novelty between the object C and these vessel for watering plant of the invention. The reason, again, even there is, you might find something which looks like a spot. You have a, let's say, water container, but you have in fact an opening, and the opening has no top cover. So again, there is no top cover on that. So for this reason, you can say, sorry, it is not relevant to the novelty. Other way of saying, this object is new over C. What about D? I let you 10 more seconds. Think carefully. Yeah, it is a hard one, in fact. I imagine that most of you have said, no, it is not relevant because there is no grip on that. Here we have a grip and here we don't have a grip. Uh, except for the grip, everything is there. You have actually a water container, you have actually a spot, you have opening with top cover, and the only point is about grip. However, you have to think about what is written and not what is illustrated. It is written a grip. A grip, if you look it up in a dictionary in English, it is said that is some area which can be taken with a hand of a person. So you shall just have an area which can be somehow taken with a hand. And if you look thoroughly here, there is an area which is suitable to be taken with the hand. This area is in fact the grip. What there What is not there is an ounce. That is called a handle or an ounce. This number two, as in the illustration, is a handle. It is, in fact, that is what you found, that it is no more here. Yes, there is no handle, but he did not ask for a handle. He asked for a grip. So in fact, if you ask for something so broad like a grip, you can be sure that this document is seen as relevant for the novelty of that document.
Of course, if he wrote, for example, instead of writing grip, he would wrote a handle, then I cannot say it is actually somehow relevant to the novelty. But he did not write a handle. He wrote a grip. So in fact, I have to say D is in fact relevant to the novelty of this document. Then the next part would be uh, E. And if you look at E, I don't give you even 5 seconds to think about it. Yeah, you are all agreeing with me. E is really relevant for the novelty of this document because, in fact, it has everything what is written here. And now about F. So I'm sure after what we discussed now, if you were at the beginning, you were not even very sure that A might be relevant to the novelty. Now we are talking about F, and you see the world a little bit differently. So now you are thinking, oh, F might be really relevant to the novelty. Why? Because it has a water container. Of course, that is a bottle, so you can put some water in it. Then you have a grip because there is an area where you can take that bottle. Then you have an opening with top cover. So there is an opening there and a top cover on that. And you have, in fact, a spot somewhere where the water can be poured outside. So, yes, it might even be, let's say, relevant to the novelty. Now, let's see that, in fact, as a patent examiner, I would say it might be accepted as not relevant. Why? The reason is because he wrote here opening with top cover and spout in two different and separated parts. So what he needs is in fact an opening with top cover and a separate spot. Here, opening with top cover and a spot are exactly the same. So, yeah, one can say it might not be relevant to the novelty. However, if you want, as a patent examiner, you can oblige him to write it clearly that yes, if you want, please write it down clearly. Opening with top cover shall be separated from the spot. Otherwise, even that uh, common bottle is somehow relevant to the novelty of what you are claiming. So you see that the proof of novelty depends much on the words which was chosen. So what I ask you now, if you are going for a search, think of that the words have their own meanings or their own technical meanings, and they can only interpret it in the technical, let's say, area where they are used to. And only that can help you to understand uh, and to somehow to choose the relevant documents. Otherwise, if you don't go for the right documents, you might interpret in a wrong manner the words, and you might actually lose some documents which are quite interesting also for you. So in order to introduce the next criterion of patentability, that is inventive step, I want you to remember only one thing from this slide. That is the case B. Let's think that, for example, we did not find anything like A, C, D, E, or F in the state of the art. We just found the B in the state of the art, and you have this invention, a vessel for watering plants, having water container, grip, opening with top cover and spout. And you see that the only difference you have between the state of the art B and this vessel for watering plants is just the top cover on the opening. Now, the question is in fact, if you find such a state of the art and you have such an invention, is just having a top cover enough to get a patent, to be patentable? We said it shall be, in fact, new, and it is new. But novelty is not the only, let's say, criterion which is necessary, but also another one, which is the inventive step. The inventive step is said in different provisions in different ways, which says something normally in this manner. They say no patents for inventions that differ only insignificantly from the state of the art. So the point is actually how insignificant is insignificant, and how much significant shall it be in order to become significant. I mean, the point is quite difficult to make. You cannot just say a top cover is insignificant. Why? If it was insignificant, nobody would use that top cover. Maybe there is a reason, a technical reason why they use it. So you cannot just come up with the idea, for example, a top cover is not significant, or for example, something else is significant. You need a way to show if the significance is really fulfilled or not. As you might know, all these laws and so on are written by non-technical people. Normally, a law, also a patent law, is written by people who studied law and so on, and they are not with technical knowledge. For most of them, in fact, these type of expressing things is normal. It is not necessarily needed that they are much more clear. However, you are in the field of patents and you are dealing with people having a technical background. So you cannot come up with those type of stereotypes like insignificant and so on. A way that for example, European Patent Office and some other patent offices found in order to give an answer to the question what is significant or what is not significant is the so-called problem solution approach. The problem solution approach starts with the point of view, first of all, let's do a patent search. When you did the patent search, then either in the state of the art you find exactly the same thing as in the invention, so it is not new and it is not patentable. Or you cannot find something like that. So in fact, you find something like the next state of the art. An object which comes closest to the state or to the invention without being identical to that. So the case of, for example, the watering plant vessel B we found in last slide, and for example, the invention, they are quite close, but not exactly the same because there is no top cover. Then the next step is actually what is the difference between the next state of the art and invention. Here in that case, for example, the difference is just the top cover. Now, and that is the most important part of this problem solution approach. You have to define an objective technical problem that is solved by that difference. So you have to imagine what was the necessity which brought people to put that top cover on that opening, and how was the world before they come up with these let's say top cover on that opening. So what was the technical problem they had so that they needed that top cover? So one can imagine if you don't put that top cover, there might uh, you might have some impurities, for example, something which is not clean and so on, which fills into the water, and that might actually cause problem by watering plants and so on. So in order to keep that away, once you, for example, fill it with water, you put actually a top cover on that, and you're sure that there is nothing else can come into the water. Okay, so that is actually the objective technical problem. No, the question is if it is obvious, if that solution was obvious for the man of skill or not. So the obviousness comes only from, again, from the state of the art. So what you have to do is actually look through the whole state of the art and see if somebody else had solved the same problem with the same means. So I have to look through the whole state of the art and I find out people in the kitchen, for example, they had the same problem. They had some pots without any top cover, and they had problem of impurity of water. So they put some top cover on it so that the water remains pure. So they solve the problem in the same manner. If it is the case, if I find the same solution in the state of the art, which was, of course, published before the application, then it is not inventive. If I cannot find that solution, then it is inventive. So that is, in fact, what is it about. Uh, in order to have some hint, because it becomes quite difficult then to judge about obviousness, yes or not, there are some hints. For example, if the solution could help to clear a prejudice. So you have the situation that the state of the art is said, don't do that, don't do that. And you did it and it worked. So you cleared a prejudice. That is a very strong hint that it is something inventive in it because you did something what everybody else said, no, don't do it. Or you overcome a technical difficulty, not only because it is overcome with an technical difficulty, but because it was unexpected result. So it means, in fact, if you put two things together and the result you find out at the end is something which is expected, it cannot be inventive. If the result is unexpected, then it becomes inventive. Also, easier solutions of what existed. There were some solutions which were very complicated. Now you find a solution for the same problem, but it is much more easier, needs much less time or much less money. That is actually a good hint that is inventive. And that is what you have to take into account. Again, I told you, if you have, for example, in the state of the art, a car, that is what you find in the state of the art. But nobody has seen any, for example, car with a mirror. So you have to see, in fact, okay, a car with a mirror, with a back mirror, it is actually new. Now, is it inventive? You have to ask yourself, just by putting that back mirror on that car, which solution you solved, and if the let's say by putting them together you have an unexpected result, yes or not. In that case, I have to say no, that is not. In fact, there was some problem. The problem is actually how to look behind you while you are looking forward. And in order to solve that problem, everybody knows you need actually a mirror, a back mirror. And that is the point, that even if there was no car with a back mirror, and your car with back mirror is new, it might not be enough to get a patent and to have all the criteria of patentability. So let's put them a bit together and think about them in a legal way. So, and ask ourselves, for example, when you have a patent, what are the exceptions to the patent? Don't forget private use and research and teaching. So you can use actually a patent for the private use and nobody can hinder you. Also for the reasons of research and teaching. What is the scope of the protection? The scope of the protection is defined by the patent claims, and these are very important part of the patents. We are going to talk even in detail about that. What is a patent claim? How to somehow even draft that patent claim, and then what is the period of protection? Normally, there is a maximum of 20 years, not one day more. So you have, once you applied for the patent, you will be given some time, and then you have to pay annual fees each year to keep it alive, knowing that the patent will die at latest 20 years after the application. So we talked about patent claims, but what are those patent claims? The patent claims is the part of the patent that define the extent of protection. Okay, uh, it means if you want to know what this patent in fact covers, you have to read the patent claim. A patent claim can be either about a process, a technical process, or about a product, for example, or means for performing a process, or a device that is an apparatus that is also acceptable as a patent claim. It might be the application of a process or use of a product. All that are accepted as a patent claim. Uh, a patent might have several independent claims only if a single general inventive concept uh, behind all that independent claims are perceptible. What I mean is, in fact, you cannot have, for example, uh, in the same patent, a claim for, let's say, the car, let's say, wheels, and also a back mirror for the car, because in fact there is, I cannot imagine of a general inventive concept which covers both of them. Okay, however, you might have that in a sender and a receiver, or in key and in the lock. If you have a sender as one of the independent patent claims, you might have also the receiver, which goes together with that sender in another independent claim. So there are two different objects. One is actually sender, the other one is receiver. However, they have to work together. So the whole inventive step behind that sender and receiver, in fact, justifies to have those independent claims in the same patent. The idea of having only independent claims with the same general inventive concept is that you shall, in fact, patent only one idea per patent. It is not permissible that you have several different inventions in the same patent. First of all, because it becomes almost impossible to know which of these idea you are infringing if you are actually on the other side. And for you also, it is not acceptable because you have to have several patents, and of course, you have to pay for several patents, not paying one patent and having several protection. So uh, there are different claim types. We talk about, for example, the claim type product. It is once you have some product type claim, you might have at the same time the process to produce that product, or a mean to perform this process, or one utilization of the said product. All that, of course, are quite with the same general concept of invention behind them, so it can be accepted in the same patent. Products are normally described by their physical characteristics in the claim. So what we don't accept is, for example, just by giving the aspects which cannot be seen or somehow actually perceived on the product. For example, a product specified through that it was uh, produced by this process. Normally, on the end product, you cannot see which process brought it to that product. So it's not visible on that product, and it cannot be accepted. If you have a product type claim, you shall give the necessary, let's say, product physical aspects in order to get that claim. Then you have actually device type claim, which is quite similar to the product claim. In that case, you might have also go for a process to actuate the device, also a process to produce that device. All that is also accepted in the same patent application. For the case of a process type claim, you might not have only the process, but also a mean to perform this process in the same patent. You might have the immediate product of this process, what comes out of the process directly and immediately. Uh, then you might have either the utilization of that product or the application or one of the application of that process in the same, let's say, patent. Uh, in the case of processes, you shall describe them by the steps, operation, and function. And that means, in fact, you need to describe what is the initial step, what is the intermediate step, and what is the final step. So you have to describe a process step by step, having at least these three steps I mentioned: initial, intermediate, and final step clearly in the application. Otherwise, normally it is not accepted. Another aspect which we ask from the applicant is to write a patent claim short and clear. Now, I gave you as example a patent, a very, very normal patent claim you might find in different patents. This is actually from these patents, so you have actually also the patent number. You can go and look for it, and you can read that patent claim and ask yourself, is it really short and clear? Is it short, first of all? And the next one, is it clear? So the question is actually short and clear for whom? I mean, it might be easier if I instead of writing all that words, I might use just these figure. I have this figure, and people who studied chemistry would see immediately what is it about. However, a patent claim has to be written in words. So you cannot put just a figure and say that is actually what I claim. You need to describe it in words because a judge would decide about that by reading those words. So now you decided about the words. However, uh, we wanted it to be short and clear. It is short and clear for the man of skill, not for everybody. So it is long, but it might be so because you cannot express it, disclose it shorter than that. It might be necessary to be so long because it is otherwise not possible. It shall be short for the man of skill, and it shall be clear for the man of skill. So it shall not be clear for me because I'm not a chemist, I'm a physicist. I don't understand what it is, but I don't bother because it is not thought to talk to me. It was thought to be written for man of skill from the field of chemistry. And from somebody from the field of chemistry, it is clear and it is short, so it is accepted. So the point about being short and clear does not mean that it shall be short for everybody and clear for everybody. It is short and clear, addressed at the man of skill from that field. In a patent application and a patent in general, you don't have only independent claims. Independent claims are normally patent claims that exist on their own. So it is said in those type of claims every necessary aspect that is needed for the patent. You might find also the dependent patent claims. These are normally special embodiments defined by an independent claim, and that the goal of them is actually to limit and to precise. So in fact, if you have a patent claim, an independent patent claim, it is normally a very broad application and, of the extent of the patent. That is the broadest you might get, in fact, for that patent. That is the independent claim. And you might specify part of it by precising, limiting as an independent claim. These independent claims have normally the form like that. They start normally with the same title of the claim, the arrangement scheme of a container wharf, and then you have some sort of, let's say, relation to the claims before that. So here in that case, it said the arrangement of scheme of a container wharf of claim one. So in that case, it does not mean that is any sort of container wharf. You have to go back to the claim one to see what was the container wharf of claim one. He takes it and then he adds much more details to that. So in fact, it becomes more precise and of course less extended in the point of view of the extent of the patent protection. So once you are in front of a patent, my question is, in fact, which type of patent claim would define the broadest, let's say, protection? Independent patent claims or dependent patent claims? The answer is independent patent claims. An independent patent claim is, in fact, showing you the broadest, let's say, extent of the protection. So normally, if you infringe an independent patent claim, you infringe the patent. And if you don't infringe the independent patent claims, you cannot by no means infringe a dependent patent claim, because dependent patent claims is per definition narrower in the scope of protection. So in order to find out if you infringe a patent, yes or not, in fact, you need to verify the scope of protection of only independent claims. And now, as we are talking about infringement of a patent, a question we can ask ourselves is about how is, in fact, the infringement of a patent determined? How can you determine actually if a patent is infringed by your act or not? So, in fact, normally you might think of two types of let's say, infringement. One is the direct use. The direct use actually infringement is happening if you make, you offer, you put in market, you sell the product, uh, a product which is in fact the subject matter of a patent, or for example, import that types of actually products, or you use a process which is also subject matter of a patent, or for example, offer, put into market, or use or import of a sort of product which is obtained directly by a process, and that process is subject matter of a patent. So in that case, it is a direct use, and that is an infringement. So either you sell that, let's say, that product, or you use that process, and the process is actually protected by the patent and so on. That is a direct use. But there is also the possibility of, let's say, an indirect use. So what is an indirect use of the invention? Is in fact if you supply or offer to supply a person other than the party entitled to exploit the patent and invention with means relating to an essential element of that invention for putting it into effect therein when a third party knows or it is obvious in the circumstances that these means are suitable and intended for putting that invention into the effect. So it might be a little bit of very, let's say, low and legal English. So I want to give you an example so that you understand what we are talking about when we are talking about indirect use of the invention. So you might, for example, make a product, and the product by itself does not infringe the subject matter of a patent. Okay? But at the moment as you sell that product, you give let's say, a piece of paper with that product on which it is written on a notice that this product, for example, can be used by doing this and that in this situation. Or for example, you can open this product and turn around it so it becomes another product. Even if you don't sell it as that product, but by indicating that you can actually change that product to a new product, and this new product, for example, would in some sort infringe the subject matter of a patented invention, in that case, it is a sort of infringement of indirect use. So even if you don't directly infringe that patent, you give somehow the possibility to other persons somehow to infringe that patent, and that is enough to be seen as a patent infringement. Now the question is actually, okay, when do I actually infringe that? And the question of when do you really infringe a patent is in fact that if the features of the alleged infringing device are covered by the claims of the respective patents, yes or not. So what a judge has to do in that case, in fact, he has to make sure what are the features of the object which is thought to be an infringement, and then he has to compare it to the patent claim and see if all the features which is in the claim can also be found exactly in that alleged, let's say, device, yes or no. If all the features can be found there, So in that case, you are infringing. If only one of them cannot be found, then at least you are out of the range of protection of that patent. Okay, so the question which is very important now is that how can you interpret the words? You remember when I talked about the novelty, I talked about the word, for example, grip. And I say grip is not a handle. So how can you actually interpret the words? And what is the scope of a patent um, regarding to the words which was used? Uh, some people actually might think that a patent claim is seen as a sort of literally accepted word. So if it is written, you need, for example, I don't know, you need a screw. So it is just enough to use something else rather than screw. You use a nail and you are out of the scope of that patent because a nail is not a screw. Okay. However, in a lot of patent, let's say, provisions, and also in a lot of jurisdictions all around the world, especially in Europe, uh, in fact, it is said that the extent of the protection goes beyond what is literally covered by the claims. So it might encompass also the equivalence to the invention covered by the claims. So in fact, it depends again on the knowledge of the man of skill. So he wrote maybe just you have to do it with, or you need a screw to do it. No, the interpretation is actually the judge would think about it and say, is it in fact necessary that he uses only the nail or the screw? Or the man of skill, from his knowledge, he would also replace the screw with a nail, yes or not? And if he says yes, he would do it, then you might still infringe that patent even if you use the nail. So uh, these, in fact, complementary aspect says you that you may go beyond that which is literally covered by the claim. And we have to be careful about the equivalence which might be accepted by a judge as well. So again, the question of infringement has a lot to do with how the patent claim is written. And the patent claim is only understood together with the rest of the disclosure, and the whole will decide about an infringement, yes or not. So you see, that is actually a quite hard question. If some patent claim is or might be interesting or might be actually relevant for the question of infringement, yes or not. And that is why we are not going, I'm personally not going to teach you about how to write a claim, how to actually decide about the infringement, and so on and so forth. For that question, you need the help of a professional person who is doing that professionally, not myself. I'm just a patent examiner. But I might give you a way how to draft the claim, at least at the very first view. And then again, if you want to have a patent claim that holds, and if you want a patent claim that has some force in it, you need to discuss that claim with other professionals. So I just want to give you an example, for example, a very simple example, how to write a patent claim for a very, very easy, let's say, object that is about a toy ball. Okay. What I want to tell you is nothing very special. It is just about a toy ball, and we want to see you invented something that easy, and you want now to have a patent on that. What is the object? And I have to say that it is actually a real case. There is a patent for that. It has not done exactly in the same way as I'm going to tell to you, but it is in fact something which goes in the direction. So it is just an example, but it ends with a real patent. So now. Your invention is about a ball that is fun to use and it is easy to catch and it looks nice. So, uh, first of all, let's start with asking yourself what are the distinguishing attributes of your invention? Okay, so what are the attributes of this very nice ball you see here? So you might find, in fact, it is fun to use. Yeah, it looks nice. And of course, it is easy to catch. So the point that it is fun to use, it is nice, uh, but sorry, it cannot be protected because fun to use does not solve the problem. It is actually just describes the situation. What you can, in fact, patent is a technical solution. So it is not a technical solution. That it looks not nice is also not patentable because the appearance of a product can only be protected by a design. We have seen it in our last course. So you might ask for a design for that, but it is not patentable. But a technical function like easy to catch, that can be patented. So as you know, in order to get a patent, you need a claim and you have to claim that invention. So let's see together how that works. So a very first naive approach would be to write a claim for a ball that is easy to catch. That is actually, I can write a patent claim, a ball that is easy to catch. What do you think about that claim? This claim is in fact, yeah, firstly, it is really broad. Do you think that is you invented the very first ever ball that is easy to catch? I don't think so. And not only that is broad, because it might be only broad, why not? More important is that it is in fact what you did here is in fact to describe how you made it to be easy to catch. So, in fact, making a ball easy to catch is a technical problem. The problems cannot be patented, but specific solutions can. So now what you have to think about is what is the technical feature that makes this ball to be easily catched. So we need a technical solution. So the next aspect would be, for example, I do a patent claim like that. I would say actually that is a ball comprising a core region and a plural elastomeric filaments radiating from the core region. So in fact, I described how I achieved that goal. Yeah, so it is in fact easy. So uh, uh, it is not bad. You give in that patent claim, let's say, uh, a way to solve that problem. So you really in these time actually solved a technical problem, and that is uh, a patent claim as itself. However, by explicitly naming the ball in the patent, you maybe did a dangerous act. What if somebody gave it the shape of, for example, a car or an apple or a telephone? So you just actually change the form from ball to the form of the, I don't know, of an apple, and you're out of the extent of the protection of that one. So these type of patent, a ball comprising a core region and so on and so forth, can be circumvented quite easily. And in fact, that is not what you want. Uh, you can maybe think about a thing that can be thrown is easy to catch and looks nice, but yeah, that is again, it is not exactly what shall be written. What only you want to do is in fact to replace the word a ball. That would be an idea to find out what can I take instead of using the word a ball, so that not everybody else can in fact circumvent it by replacing the shape of the ball. So we might think of replacing it with a general concept, for example, an amusement device. We can say instead of ball, an amusement device comprising a core region and a plural elastomeric filaments radiating from the core region. So I have to say, yeah, that is actually a good idea. Now you have found actually a way to be as general as possible, but also to solve a technical problem. And that is a very first good, let's say, patent claim. Now, point is actually we cannot stop here. You need to do a prior art search, and that prior art search will show whether the invention, as you claim it here, is actually new or not. So now we have to do the search. I let you do the search after the third part of these series. Uh, uh, so we don't talk about the search, but let's think that your patent attorney did the search for you. So let's imagine that your patent attorney did a patent search and he found this document that is US 3759518 as it is shown on this slide. And it is about a food implement toy, and it discloses a very similar invention. It also relates to a toy, has many flexible strands fixed on a core. So now you have, in fact, to carefully analyze what is contained in that patent so that you can determine what might be new about your invention. So you can find in that document, for example, the sentence like "say toy having a plurality of flexible strands." Uh, it looks much alike what we had, in fact, claimed in our first patent claim. So let's compare these two inventions. On the one side, let's say what you claimed as your invention. So you did actually this one, an amusement device comprising a core region and plural elastomeric filaments radiating from the core region. Now, you find that the earlier patent actually only describes a disc-like shape. That is, for example, the fibers are explicitly stated to radiate in a particular plane around the core. So it is a toy of a disc-like body, including a plurality of flexible strands radiating outwardly from said center, having sufficient inherent rigidity to retain the pattern of a circular plane. So, in fact, it is about these flexible strands that are somehow rigid. That is not what you want. So there is differences between them. This earlier patent reveals that the function of these strands is to make the toy fly better and be easier to kick around. And the function, so that is the problem which is solved, is not that it can be caught easily. It is not exactly the same solution. So the explicitly different configuration of the stated different function, in other words, your invention is new because you changed the orientation of the strands from a two-dimensional plane to a three-dimensional globe, and you achieved a new function, which is it is easier to catch. Moreover, it was not obvious to a skilled person to modify the closest prior art, that means actually these American document, in the way that your invention does to achieve these results. So if you change now your claims accordingly, you can still maybe get a patent over these, let's say, application. So what we now know is that, in fact, the patent claim as we had it, it was maybe too broad, so it is not new. But the difference is, in fact, we had a three-dimensional form. These are floppy filaments, and the American document is making a disc shape form, so it has a two-dimensional form, and it is in fact made of rigid, let's say, strands. So what we are doing is, in fact, we are adding some more aspect. It is radiating in plural angularly offset planes from the core region. And in fact, that makes us new to the state of the art that we found. It becomes new, and it has also an inventive step because the modification yields new function of making it easier to catch. It was not at all why these persons did this one. They wanted to kick it easier around and not to catch it easier. So now I have a patent claim, new and inventive, due to one I found in the state of the art. Now, uh, what is the claim I can file now? An amusement device comprising a core region and a plural elastomeric filaments radiating in plural angular offset planes from the core region. So this is actually the claim you had, and for maximum protection against competitors attempting to circumvent your patent, you would normally file more than one claim. As I told you, you need also independent claims. Why are these independent claims necessary? Let's think of a very simple patent claim. You might actually claim a wheel. Okay. So now we all know wheel is not new. If I actually patent that claim like that, a wheel, uh, the very first thing I will get, sorry, will is not new, it's not patentable. If I don't have any other claim, like claim number two, I might, in fact, get no patent protection at all. Now, in order to have this possibility, uh, uh, of course, the inventor wants the invention to be patented in such a way that the resulting patents are difficult to circumvent, so it shall be as broad as it can. However, making very broad patent claims is very risky, as there might be related prior art which is not known to the inventor or even to the patent attorney, and if you cannot find it during your prior art search. So if a patent has only one broad claim and that claim is destroyed by existing prior art, then there is no patent protection at all. Therefore, in practice, most patent applications have both one or more broader independent claims and a multiple of narrower dependent claims. And the independent claim usually describes the invention in a very general terms to allow a broad interruption of the infringement lawsuit, but the dependent claims usually describes specific ways of realizing the invention that the inventor regards as economically attractive. So the dependent claims refer to the independent claim and specify some further parameters that narrow down the scope of the claim. That is what we talked about before as we talked about the claims in general. For example, here it is about a will. Will being too broad, maybe then you have the state of the art. Uh, that is the prior art about the will. So in fact, you maybe lost the whole, let's say, broader claim. However, a will comprising an annular winding of a fiber in a groove is much more specific, so that at least these specific the application is protected by your patent. So there are other example. You might actually, in other cases, you might, for example, go for an application, a battery made out of iron and sulfur. It is, of course, a very broad way of claiming a battery. And then in a dependent claim, you might be more specific and you say the battery of claim one, that is a battery made out of iron and sulfur, in which the sulfur is deposited as metal particles on a graphite electrode. Then even though the patent examiner or later the court might find that the battery made of iron and sulfur had been published before, the inventor might still be able to get a patent because he is the first to have used small sulfur particles on graphite for such a battery. So that is actually what comes out of this type of thinking. Then uh, in this example, we might formulate two further dependent claims. For claim two is, for example, the device according to claim one, characterizing that it has substantially spherical configuration. So we did want a ball, so now we have the ball by making spherical. And another independent claim and another dependent claim, a device according to claim one, characterized in that the outer ends of at least some of the filaments include enlargements. These enlargements, in fact, make it easier to catch and they cannot somehow slip out of it. This is actually an example of how the final claims that you might use in your patent application where the main claim covers your invention in general terms, and the dependent claims describe how you think the invention will be specifically realized in the form that you might need. And then you go for the application. So note, although the enlargements are part of the original invention, they are not described in the independent claim, but only as one of many protected ways of putting the invention into practice. As the inventor, you know that the invention also works without these enlargements. It would work better with enlargements, of course, but it would work only also without enlargements. And you do not want competitors to circumvent your patent simply by omitting them. So you protect them in a dependent claim. So the point is that take the claim one, of course, as general as it is possible. You cannot do it as broad as you want, because there's a state of the art, and the state of the art would decide how broad it might be at the end. So that is now you send it to your patent office. Here in that case, that was sent to European Patent Office, and of course the patent office, which is in charge of the examination, will perform their own prior art search, and they will consider whether the invention as claimed here is new, and if it is non-obvious, if it is actually inventive due to the state of the art. What happens now is that actually your patent office have found additional prior art. In this additional prior art, it is about a German patent, the German patent DE, like Germany, 3121758, where you might find these sentence. I have to say, actually, the patent examiners are quite trained patent searchers to find relevant prior art. So even if you did your own patent search, they still might find some other state of the art that you have not seen before. So in this example, the examiner found this document, and it is about a self-adhesive mold element that are equipped with spike-like rods of bristles, characterized by the rods that are attached on a core and that are made of an elastomeric material. If I see through the figures, I can see also easily that these elastomeric materials are not just in the plane, but they are in several regions. So they have the form that we, in fact, claimed in our main claim. So again, let's make a comparison between what we made as claim and what was described in the state of the art. Our claim was an amusement device comprising a core region and plural elastomeric filaments radiating in plural angularly offset planes from the core region. Here we have spike-like rods attached on a core made of an elastomeric material. And if you look through the figures, it is clear that they are in a plural angularly offset planes. So they are not just in a plane. All that is already shown and claimed in these German documents. So we have to say, sorry, as patent examiner will send you, you have to amend your claim if you want your invention to be protected, which means, in fact, they don't say your patent is no more valid, it is dead. They give you still the possibility maybe to amend that claim. However, you can only amend that claim if you have enough disclosure that allows you to do that amendment. So when you take these type of responses from your patent office, what you have to do is, first of all, did, for example, the patent office overlook any important features of the invention? Okay, then uh, you have to reply. For example, that is, you have the possibility of applicant reply. You make some amendments to the application, and you explain the relationship between the invention and the prior art. At the same time, you have to reflect about how can the claims be amended in the invention in such way that it is new, considering all the prior art, and of course considering what is disclosed. So your work is, in fact, you have to demonstrate that the claim must be interpreted differently, or you have to change them. So if you are not in a situation that you can show them, you have to interpret them actually differently. What is, I have to say here, in the case, you have to change them. You are not allowed to change the invention that your application is about, but you are allowed to make the wording of the claim fits more precisely to your invention, and your invention is what is described in the description and in the drawings. So you have to check the document found by the prior art search. Then you have to check if any features are not disclosed in that prior art, and what are the advantages of your invention when you compare it to the prior art. Now, we are now going to make a thorough comparison between the invention on one side and what was found as prior art. You remember we had two prior arts, one which was in fact found by your patent attorney, the US document, the other one with your that was the one who was found by your patent office, that is the German one. We can take a look to the technical features of the invention and the advantages or the technical results. So you have actually technical features of a core region plus flexible filaments. Then you had the question of a plurality of angular planes. Then you have the question of floppy filaments, and that all brought it to the advantage that is easier to catch and flies less far and doesn't break things. Okay, so if look, for example, through the US document, we see that the US document has a core region plus flexible filaments, so do actually the German one. About the plurality of angular planes, the US one had a disc shape, so they didn't have that. The German document has that as well. The US document had some floppy filaments. Here, in the German document, it was about actually rigid, really rigid, in fact, strands, which does mean that there were no floppy filaments, because the idea of these German documents is to be self-adhesive. So once you hit somewhere, it sticks to that. The technical, let's say, reason of the US document is about the floating movement. None of them is easier to catch, and none of them is thought to fly less far and doesn't break things. So both of them have other advantage and technical results. So it means that actually we are in a very good situation, depending how and what we have disclosed, we might have a chance to get a patent out there. So in the next step, we will somehow go to find the result of our analysis. Based on our analysis of the relationship between the invention and the prior art that was found, we can reformulate now our claim in such a way that the invention as claimed is new and patent can be granted. Now, in order to do that, in fact, I have to make sure that the combination of what we have seen, maybe floppy filaments and let's say plurality of planes in angularly offset planes, uh, is in fact the combination of them all is not disclosed, so it is new and it has a unique benefit. Given our knowledge of the prior art, it is also not obvious to combine these elements because none of these documents wanted to have this new effect of being easily caught or let's say the possibility of not let's say flying far. So now we have to rephrase our claim to distinguish it from the German document. And it became like that. It is now an amusement device comprising a core region and a plural elongate floppy. Now we have the floppy in it, elastomeric filaments, each having a cross-sectional dimensions which are significantly smaller than its length, radiating in plural angularly offset planes from the core region. So look how complicated the claim for this simple invention has become now. Now you know now why patent claims are often very complicated in practice, and you have also learned how to understand them much better. It is often helpful to consider the claims as a bundle of features that together represent the invention as it is protected. Now you have changed your claim compared with what you originally filed. Of course, once you have filed the patent application, you cannot simply change it as you like. For example, you cannot introduce completely new elements, but any changes had to be supported by the document that you originally filed. So that is why it is so important to look thoroughly through what it was filed originally as the disclosure. And you have to make clear that the claim in that form is supported by the original description that was filed with the EPO. So let's take a look at it, how it was filed with your patent office. Uh, it was written, for example, this invention pertains to an amusement device and more particularly to a throwing catching device, which is especially easy to catch. That, in fact, is making clear what is, in fact, the goal of that invention. One of the problems with many conventional throwing catching devices is that they tend to bounce and sometimes hurt to catch. That is exactly what we don't want. A general object of the present invention avoiding any tendency to bounce, grasping, and it prevents throwing or hitting it very far, break anything on contact. So that is actually all that supports the inventive step and it is different technical result which was asked for. Then we had in our description, according to preferred embodiment of the invention, then we say device 10 is formed with large plurality of elongate floppy elastomeric filaments, each of which is as clearly evident in figure 1, has a cross-sectional dimension which are extremely small in relation to the length of the filament. That is the difference to the German patent. As will be more fully explained shortly, these filaments are joined in a central core region in such a manner that they radiate outwardly in fairly uniform, dense, and bushy fashion in multiple angularly offset planes. That is the difference to the US patent, to form a substantially spherical configuration. So you will find, for example, in green, what makes you different to the US patent, in blue, what makes you different to the German patent, and in somehow, let's say, in a brownish color, what is the technical effects you asked for. Doing that, now the patent is finally granted. There is, in fact, a patent that can be found under this number. There is an EP patent, EP295114. If you want, you can go and see the patent really exists. And that was how this patent was actually granted. So now take, in fact, a break, and then we are going to talk further about how to get a patent. The next step is actually, okay, now we know what is patent, what is novelty, what are the patentability criteria. We have even seen how a patent claim is drafted, what is the difference between independent patent claims and dependent patent claims. So next step, okay, now how can I get a patent if I want to make a patent registration?
So till now, actually, we talked about what are the patentability criteria. We talked about actually what are the patents in general. How can they be perceived as an exclusive right, and so on and so forth. What shall be fulfilled if you want to have a patent. We even talked about the fact how to, let's say, see patent claims, how to draft patent claims. What are they? What are the patent claims, and why are they so important? The part which we did not discuss up until now is actually how to get a patent. In fact, there are different patent registration procedures, and most of the time, at the end of this registration, a patent will be issued and granted that will have exactly the same effect as the other ways of, let's say, if we have used other ways of protection. So why these different procedures, why they might be interesting, we will see in short what are they, and what are the differences, and when they might be interesting. So there are mostly three different ways that lead to a patent registration. The easiest one is, of course, to go for a national application. So if you want, for example, a patent in your country, whatever the country is, that is easy to go to your own patent office, to your IP office. Then you might get a patent application there. The patent will normally actually be examined at these patent office, and then it will be granted there. In some regions of the world, you have also the possibility of a regional application. One of the most famous examples, and one of the one who are quite relevant in the world of, let's say, economic affairs, is of course the European Patent Office. The European Patent Office is situated in Munich or in The Hague. There are two general directorates.
and it is a regional application for a maximum of 38 European countries, plus two extension countries, and that is actually a way of a regional application. Then you have, of course, also always the international application, which is done with WIPO. WIPO is the abbreviation of World Intellectual Property Organization, which is perchance here in Geneva in Switzerland. And with which sort of application you might make an application simultaneously for up to 153 countries. So let's take a look at each of these in order to find out which one of them might be more interesting in for which case. So in the case of a national application, it is you're doing the national way by just making a national application. Let's say, for example, here in Indonesia, you do there the application. The very first application would give you the possibility of using the priority rate, a priority year, during which you can make application in other countries without losing the very first date of application. So you will have an application, for example, in Germany, in Brazil, or in other countries, using the priority right, and then through which you will have the right on, let's say, novelty and inventive step dates, which is will be counted before the priority application, which is the application you filed with your own patent office. Then normally after about 1.5 year, there will be a very first application publication, that is the publication of that application. It means that actually the patent office will publish the application as you gave them. Normally they don't do anything on that. It is just stating that is an application and not a publication. Then normally you will have some time during which the patent office will ask you, do you want that it is examined? You might want the examination, so they start with the examination, and then after the examination there will be grant of the patent. As soon as it is granted, there will be another publication. This time it is the publication of the patent, and this patent is, however, valid from the very first day of application retrospectively. However, what is valid, we know it only after granting. So the examination will decide which part of the patent or what is the extent of the accepted claims, as we have seen, for example, in our example of claim drafting. But what is accepted is accepted from the very first day on. And of course, in order to keep that patent alive, normally you have to pay annual fees, and these annual fees will make it actually that it is somehow renewed up until the end of protection. As I told you, in most of the cases 20 years and not one day more. So that is the way it goes in the national way. So national application and national life of patent is quite normal. So in fact, you can do it in every country what you want. You can actually make a national application in all the countries which are interesting for you. Well, the point is actually normally you don't have the application at the same time in all the languages. So maybe actually you ask for a patent in the United States, in that country, you can actually apply for the patent in English. So why not? But I'm not sure if, for example, you can apply for the patent also in the same language at the same time in another country. For example, I don't know. In Germany or in Indonesia and so on and so forth. So depending on the provision, you might not be allowed to apply in another language as the national language of that country. So that means actually either you have the translation of the whole patent in all the languages at the same time, which is quite impossible. And we have seen that the words are very important. So we have seen that, for example, grip is not exactly the same as handle. So these are actually the translation you don't want to do with the Google Translator. So normally, actually, you can use these priority year in order to make these type of application in other countries in order to make the translation. But again, 1 year might be enough, might not be enough. You have to see. Uh, so there are other possibilities in order to help you by these type of decisions. In which countries do I have actually the translation? Shall I have the translation from the beginning, yes or no? One of them is actually the possibility of a European procedure. It is a unique procedure for several European countries. It ends with a unified examination. That means actually European Patent Office will examine the patentability of your invention, and they examine a complete examination, including novelty and inventive step. All that is checked. However, after the patent is granted by the EP, by the European Patent Office, it is then divided into several independent patents in each of designated states. So that means that from that point on, your patent, which was somehow managed in a central manner at one patent office, it is that European Patent Office in The Hague or Munich, will live his life in Switzerland, in Germany, in France, in England, in Great Britain, of course, in Austria, or any other European countries which was designated separately. These patents can be actually losing their values in one of those countries and live still in another country. You can actually let die one of them by not paying annual fee in one of those countries. That does not affect others in other countries. So they are living really a life quite independently. One thing you have to know is actually that European Patent Office has three official languages, so you can actually reach out your patent in only three languages, that is German, English, and French, and that is actually accepted only in one of those three languages. So good thing for us in Switzerland is that two of these three languages are also national languages in general in Switzerland. It's actually German and French. So for us is actually a good thing. For some countries in Europe where English, German, or French are not their national languages, for Italy, then you need, of course, also translation when you are coming to this national phase that we talk. So, what is the lifeline of such a patent? It is very similar to what we have seen for the national application. You start with an application that there will be actually a publication of application after 18 months. Then at a certain point, they will start with the examination, and after examination, there will be some changes and it comes to a grant. After grant, you have the publication of the patent, and at the moment of the grant, European Patent Office will ask you, oh, it was nice that you asked for 38 plus 2 countries, for 40 countries, so please give us at least the translation of the patent document, or at least the patent claims in all of those countries where you want. As I told you, for France, for Germany, for Switzerland, for Great Britain, for example, you have not to do anything because all the European patents have granted European patents have their claims in these three languages. So we accept it as if it was examined by us. But if you want to keep it, for example, in Italy, you have to also give some Italian translation of the patent or the patent claims in order to keep it alive. From that point on, the administration will happen at the National Patent Office. So in order to keep it alive in Switzerland, you have to pay the annual fees separately. And then you have to pay it separately in Germany, separately in Great Britain, and so on and so forth. Normally, with the application, you pay the annual fees for 3 years, and from the third year on, you have to pay annual fees even if it is still not granted. So you pay actually these annual fees in a central manner up until the grant, and from the grant on, these annual fees will be paid in each country separately. Okay, so 38 plus 2 countries, 40 countries, quite good. Why not? Yeah, you can actually, it's a big amount of the part of let's say countries out there, but it is maybe not enough. What happens if you want more than that? If you want also other countries rather than European countries? Is there a manner to have a world patent? The answer to that question is I can give you it now. No, you cannot have a world patent, but what you can have is to have an international application, and this international application through what we call PCT procedure. PCT, that stands for Patent Cooperation Treaty, that is a procedure to make one application for up until 153 countries. Again, it is just a unified application procedure, not a patentification procedure. There will be no patent examination which is done by WIPO. WIPO accepts only your application, and through the PCT procedure, through this treaty, all 153 countries accept that as a sort of application for their national offices. So it is actually only a good base for a preliminary investigation. And I told you, if you don't have this procedure, you have the procedure of, or you have the possibility of let's say, we call it the possibility of having the priority, but the priority is only 12 months. And this procedure gives you up to 30 months after filing or priority date the possibility to still decide in which of these countries you want to keep the application. So only thing you buy out there is you buy time, and you decide to have a bit of more time regarding the 12 months we had by the let's say the priority possibility. So in 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 general, what happens is in the PCT procedure, you start with a very first application at your national level. You wait the 12 month of the let's say priority, and after 12 months you ask to do a PCT application out of it. So your receiving office, your own national office will then send this application to WIPO in Switzerland. And from that point on, WIPO will stay still actually wait for 18 months. I'm not sorry, 6 months, 6 months later. So in total, 18 months, and they will publish that application. This publication is done by WIPO, and that is why people think there would be actually a world patent out of it. No, that is just the publication of application done by WIPO, but that is nothing still decided about the patentability and so on and so forth. So WIPO still waits 12 more 12 more months. That is in total about 30 months. So 80 months plus 12 months, that is actually 30 months. And then he will ask you, okay, you asked for, let's say, uh, 153 countries. Now, which of those countries do you want really to keep still? That is the moment of entry into national or regional phase. So that is the moment you can decide among the countries you want to keep that patent. And that is the moment you have to deliver your translation. So in fact, you have all that time, 3 months, in order to make a market search, in order to find out which country or which countries are of interest for you for the sake of application. Then the examination, granting and publication of the grant, all that will happen only on the national or in a regional basis, not generally in a let's say from WIPO. So there is actually no way of having a world patent. The examination, the granting, and then after granting, we know it, even if you have some regional phase possibility, like in Europe, after granting, it will become a national patent. So at latest, for the sake of enforcement of your right, of your patent, you will come back to a national way. So in order to enforce your right, you will enforce it on a national court. There is no possibility of international court for the time being. Maybe it will change one day, but for the time being, the only way of, let's say, enforcement is a national enforcement. So you do actually a national enforcement, national examination, or a regional examination, but national enforcement. So these are different ways, and as I told you, the differences are not that much in what comes out, but in having some more time or a little less time. Also, a difference in the case of regional let's say, application, where you might need not the translation in all the languages. So again, that is maybe some difference with which might give you the possibility to do a regional application. In the rule and in general, it always depends on what you want. So if you want and you know which countries are relevant for you, you can directly start with national applications, or for example with a regional application if it's about Europe. If you have just few countries, one or two or three countries, even in Europe, you have just 3 European countries. It is maybe cheaper to ask for these one patent in these 3 countries. But if you want more than 3 or 4 countries, it is cheaper to do, for example, in a regional way. If you are not sure about countries where you want to apply for, you want to have enough time to decide about that, then the PCT procedure will give you the possibility to have a bit more of reflection time, that is 30 months. So before starting now with our last part of, let's say, training, which is patent search, we have to at least try to understand how does a patent look like. We will see that patents are normally very boring publications because they all have always the same way. They are always published in the same manner. So they're really boring. They're not very, let's say, exciting forms of literature where you are very happy to read them because everything changes each time. No, a patent is very boring, but being boring has a lot of, let's say, virtues and a lot of advantages while searching for that patent. Why is it so? Let's look at the patent publication. So if you go for a patent publication, on the very first page of it, you will find what we call the bibliographic data. So you find almost always on the top on right hand side the patent or the publication number. And these publication number, just this number will give you a lot of information. Normally the very first two let's say, the very first two letters are defining the patent office which was in charge of publication. EP like European Patent Office, CH like Switzerland, then you have US, yeah, like United States, and so on and so forth. You have also other data out there. For example, the date of publication, date of filing, maybe also a date of priority, then the date of the publication of application. You will have also the possibility to see the data about the patent owner, or for example, the let's say who is the inventor. So for example, here the proprietor, the patent owner is actually Syngenta Participations AG, which is actually a Swiss-based company, and the name of inventors, for example, is John A. Riles is one of the inventor, for example. You can find out. You can find out also such let's say such an information like a title. So you have it actually a title of that patent, and so on and so forth. All that you can find on only very first page. So without reading further, you have a lot of data out there which can be read on the very first page, and they are always at the same place. If you look here, you have some numbers. For example, here, just in front of the title, you have the number 54. Good thing about patents is that these numbers are somehow standardized, and people are using it in all languages, all patent offices for the same manner. For example, if you have a patent in Chinese and you cannot read Chinese, you want to know, okay, what is a title, for example. What you have to do is to find out the number 54, and what is written in front of the 54 is about the title. So you go to somebody who can read Chinese and you ask him, please read me, I want to know what the title is about. So you see, actually, even that is a good manner to help you to find out in what you are searching for. Then a patent is very structured. So you start normally very in a very structured form. So you start with the definition of invention. You have to indicate the invention field, what is state of the art, what was the problem, what is the solution to that problem, what are the beneficial effects. Then if you have some figures, you have to give some legend of figures. Then you have the description at whole and preferred embodiments, and then you will finish everything with a patent claim. So in the case of our patent that I showed you now, you can find all what I said exactly in the same manner. So very first two sentences is dealing what is the technical domain. The present invention relates to compositions for controlling plant pathogens by employing as active ingredient a combination of whatsoever. That means, in fact, if you are not searching for controlling composition for controlling plant pathogens, so let it go. You don't need to read this document. Go away. These very structured way of doing things give you the possibility to stop reading further as soon as you are sure you don't want that patent. Why is it so, and why is it so important? We will see when we are doing our patent searches that there is a huge amount of patents out there, about 120 million documents. So it is by no way possible to read all of that document. So the idea is actually to reduce the number of patents you read to the one which does really matter. And that is a big help to have that in such a form. Then in the next paragraph, you describe normally what is state of the art. You're not the very first one who is doing that. Normally, there were some people before you. Then the state of the art had some problem. What is the problem of state of the art? And then what is the solution of that problem? The solution of that problem being normally the invention. So now you have actually the invention. And if you want to know how this invention works, then you have to read further. Then you have the complete description, which describes in a manner that the man of skill can do it. And that is, in fact, the disclosure of the patent. Once the disclosure ends, then you have actually the patent claims. Don't you remember what we said? How the patent claims are done. You have the independent patent claims and you have dependent patent claims. Normally, the very first patent claim is an independent patent claim where it is described in all details what is in fact claimed here. And then even the patent claims are very structured. You have normally a preamble which describes the state of the art, and then you have the characterizing clause which make that new and inventive to the state of the art. So normally patent offices ask you also to write the patent in that way, so that you separate the characterizing clause and preamble being actually the state of the art, and the characterizing clause is what comes next. Then you have also in many of the publication also a search report which gives you the possibility to evaluate what is the state of the art due to PCT minimum documentation. So it is a minimum let's say number of patents or which shall be included in your state of the art search. And there is actually a sort of estimation if after the documents which was found, your invention is new, it is inventive, or does it have any, let's say, other aspects that can be accepted maybe as a new inventive. So that is also one thing which is quite important when searching for patents. And you can use also these search reports to find out other documents which are from very close, let's say, areas, fields of technology, and you can use these search reports uh, quite often, because that is something which was searched by a patent searcher, a professional patent searcher and examiner, and that gives you also an overview about the state of the art. So I thank you for this part. Uh, uh, let's start with the next part of our training, which is patent searches.